Writ jurisdiction. Five types of writ. In 1950, the Indian Constitution came into force. Constitution guaranteed several fundamental rights under Part 3, and both Supreme Court and High Court were entrusted to protect these fundamental rights. Constitution expressly conferred the writ jurisdiction to Supreme Court and High Courts under Article 32 and 226 respectively. Article 32.2 expressly says that Supreme Court shall have power to issue direction or orders writ including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate, the enforcement of any fundamental rights conferred by the third of the Constitution. 1. Writ of habeas corpus. Habeas corpus is a judicial order issued by the Supreme Court or a High Court directing a public or a private agency to release a person in their custody. Writ of habeas corpus is aimed at protecting personal liberty. It is used in securing the liberty by releasing the person whose detention is illegal. Second writ of mandamus. Mandamus could be issued only to enforce a public duty. Mandamus is an order issued by the court to any public authority to do a specific act or forbidding the authority from doing some specific act. This writ is mostly used for enforcement of public duties when such authority failed to perform. It could also be used to certain the authority who is doing an act which it should not to do. The purpose of the mandamus is to keep the public authorities within the limits of their jurisdictions. Writ 3. Writ of prohibition. Prohibition is a judicial writ issued by a superior court to inferior court, restraining from continuing the proceedings. It is one of the oldest writ largely used in restraining the inferior courts from encroaching the jurisdiction of superior courts. Unlike other writ which are corrective in nature, it is a preventive writ. Prohibition is almost similar to certiorari, issue when the proceedings are pending before the authority, whereas certiorari is issued when the proceedings are already completed. Writ of certiorari. Number 4. Certiorari means to inform. Initially, this writ was developed by the king. When king requires to certify any information ordered by this writ for necessary information be provided to him. It is ordered by the court to any judicial or quasi-judicial body to transmit the record of proceedings, disposal of or pending therein for scrutiny. It is issued to correct the gross errors made by the lower courts. The purpose of this writ is to keep inferior courts within the limits of their jurisdiction. By issuing the writ, the superior court would quash the orders of the inferior courts when they exceed their jurisdiction. In that sense, it is a writ corrective in a nature. Number 5, writ of quo warranto. Quo warranto means by what authority it is writ used to be issued to take the office back from the person who is holding such office without authority. It is a judicial order issued by which a person who is occupying any post or authority, he or she holding such office. The aim of the writ is to oust the unauthorized person from holding the public offices. Quo warranto confers jurisdiction to the court to control executive action in matters of appointment to public offices. It protects the citizen from the holders of the public offices to which he or she has no right. Writ of quo warranto could be used to scrutinize when qualifications are prescribed for a public post.